Good evening to all the learners and the academic counselor, Mr. Ramanamurthy. I welcome you all for today's online counseling sessions for the PG certificate program in patent practice. Today is the beginning session, and I hope everyone has received the counseling schedule. As per the schedule, you all have to attend and gain the knowledge from the academic counselor. We are having the academic counselor with us, Mr. Ramanamurthy. He is having a very good experience in the field of this patent practice, and he has written good number of articles and presented papers at the national and international level seminars. But he is a asset and having good knowledge in the particular subject. I hope everyone will utilize this opportunity, and I request you all to utilize these academic counseling sessions effectively and make your examinations very comfortably and complete the program within the stipulated time. I also sometimes monitor these sessions. Whenever you have the issues or any problem, please speak with me, and the academic counselor is very much available for clearing of your academic doubts. I wish you all the best. Thank you, Mr. Ramanamurthy ji, for accepting our invitation and agreed to take the sessions. Mr. Ramanamurthy.
Good afternoon, sir. Sir, due to some technical issue, I was unable to take the class right now. Just give me 5 minutes.
Yeah, please go ahead. Please
Yes.
go ahead. Comfortably, you can take the session.
Just give me 5 minutes time.
Yeah, please. Thank you. These recorded videos we are going to upload in our RC Vishakhapatnam YouTube channel. Because of you are from the different RCs, and you can subscribe our RC Vishakhapatnam YouTube channel, and you can watch even later time also. You can watch the recorded videos of these particular counseling sessions. It is going to be almost all the 10 days, and this complete schedule we have uploaded in our website, and we are having only just 11 students, 11 students from the different RCs, of which I think today only I'm seeing only 2 students. That you at least use these counseling sessions for clearing of all your academic doubts related to this subject. Yeah, good. సార్ మీకు అయిపోయిన తర్వాత ఇమ్మీడియట్ గా తీసేసుకోండి క్లాసెస్.
Okay, sir. Okay.
యా ప్లీజ్ గో హెడ్. ఓకే.
Good afternoon, friends. This is
Okay. It is okay, sir. Hello.
yes, so just right.
Now it yeah, please go ahead.
Yes, sir. It is everything okay, sir. Right now.
Yeah, please go ahead.
Okay, sir. Due to low network, I was muted my screen off. Okay.
Okay, no problem, no problem.
Good afternoon, friends. This is V. Ramanamurthy. Yeah, I am your academic counselor for the two papers, MIR021 and MIR02. So we should deal 2 days with MIR021, that is with regarding to overview of intellectual property and the general overview of intellectual property, and the other paper is international framework patent protection. So in the general overview of intellectual property, they allotted 2 days of class. So we will discuss the overview of intellectual property rights and patent and technology development in the first day. In the next class, tomorrow, we will discuss the enforcement of IPR and litigation and settlement of disputes in the case of IPR. So remaining last 3 days, we will discuss MIR 022 paper. So today, as a coursework, today we have to discuss the first two chapters of the overview of the intellectual property right paper. So the first one is Introduction to Intellectual Property Rights in India. So the intellectual property rights plays a crucial role in driving innovations, economic growth, and technological advancement in India. They encompass a range of legal rights that protect creation of the mind, such as inventions, literary and artistic works, designs, and symbols used in the commerce. At the same time, India's intellectual property rights regime is governed by a comprehensive legal framework that ensures the litigation, the recognition, and protection of these rights. So, this framework is designed to encourage creativity, promoting investment in research and development, and foster a competitive market environment. So, what is the called as property and intellectual property? What do you mean by property? Basically, the property means it is a material, some material object belonging to a particular person. So, the property, in layman's sense, it can be called as a belonging to one particular person. But in the legal sense, we can call this a property refers to a bundle of rights that the law confers on a person by virtue of the ownership and possession of the object. So property can be divided into two kinds. Number one is tangible or corporeal property. Second one is intangible or incorporeal property. So tangible property. The tangible property is nothing but one who can perceive the by senses by touching that. Like if you place some bottle, if you touch that, then it can be called as tangible property. Or if you the building is there, if you see and touch it, then it can be called as tangible property. So these lands and buildings comes under this tangible property. These are also known as corporeal property. The other property is intangible property. This is also called as incorporeal property. For example, copyrights and patents. What is this? So intangible property, it is not available in physical form, but it is the creation of human mind. Okay, the difference between tangible properties and intangible property is nothing but in the tangible property, the possession of the physical property is possible, but in the case of intangible property, the possession of physical object is not possible. So what is the definition of intellectual property? So the definition is the property which was created by the application of human mind, and it is non-physical or intangible, and it derives its value from the ideas. So this is called as intellectual property. So the value of property depends on two things. Number one, scarcity, and number two, demand. If any of these, if the scarcity increases, then the value of property increases. If demand increases, the value of the property also increases. Next, what is the significance of this IPR, intellectual property rights? So what is the significance? The significance, the domain of the intellectual property is expanding fast as knowledge and information became a key drivers of techno-economic growth and of societal progress in general. Intellectual property is a dynamic area as science and technology make rapid advancement, and as competition for markets becomes ever fiercer. Human ingenuity is throwing up ever new ideas and newer products. So based on this technological advancement, the techno-economic growth of the society, the innovations, ideas, they're increasing. In this dynamic era, these IP is expanding day by day. Next, what is the historical perspective of intellectual property rights in India? We can demarcate the historical perspective into three periods. Colonial era, which was starting from 1757 to 1947, post-independence era, 1947 onwards, and global integration, 1990s onwards. In the colonial era, before that, we don't have any legislations with regarding to intellectual property rights. During the colonial period only, they make some legislations based on the British colonial laws. The British East India Company introduced primitive forms of intellectual property rights protection in India, primarily focusing on patents and trademarks for industrial growth. So these protections were limited in scope and largely served the interests of British companies. So during the colonial era, especially 1914, I think, so they make a legislation was made by the British East India Company with regarding to this patents and trademarks, but they particularly see in the perspective of the British companies only. After the post-independence era, India established a comprehensive intellectual property rights framework based on that colonial legislations only, with each encompassing patents, trademarks, copyright, industrial designs, and geographical indications. So the objective was to foster domestic innovation and protect the rights of creators and individuals. So after the independence, we are making legislations with regarding to intellectual property rights to foster our domestic innovations and protect the rights of the creators and investors. But in the global integration, that means after the liberalization, economization, globalization of 1990s period, this period led to increased integration into the global economy, necessitating reforms in its intellectual property rights system to align with international standards and agreements. So this globalization, LPG era, liberalization, privatization, globalization era, resulted in stronger protection and enforcement of IPRs in the global innovation market. So what are the kinds of intellectual property rights? Basically, intellectual property rights can be classified into two kinds, that is industrial property and copyrights. Again, the industrial property can be divided into subdivided patents, trademarks, geographical indications, industrial designs, integrated circuits, and layouts. So, what are the Indian Patent Act? How Indian Patent Act evolves? So, in the historical roots, the Indian Patent Act 1970 was there. We are following the Indian Patent Act 1970, but it was based on the British legislation only. This act, building upon previous legislation, provided a comprehensive framework for patent protection. It aimed to balance the interests of investors with the need for promoting technology diffusion and access to essential medicines. This act was also amended, further amended. The act has emerged several years amended, but we are following the most recent amendment of 2005, which align with the international obligations and address concerns regarding patent eligibility, product patentability, and the scope of patent protection. If you see in the 1917 Act, which was enacted before the TRIPS agreement, before the World Trade Organization came into force. But after the World Trade Organization, it laid some global rules regarding maintenance and protection of the patents. So based on that, we amended in 2005. So to comply with the international obligations and addresses concerning regarding the patent eligibility and patentability, scope of the patent production, like that. In recent, the Indian Patent Office is actively engaged in strengthening the patent examination process for promoting transparency and addressing the challenges related to patent litigation and infringement. So the Indian Patent Act focusing on fostering a robust innovation ecosystem that encourages research and development. So, but what we want with Indian Patent Act? So the Indian Patent Act is expected to continue the evolution to address emerging technological advancements such as artificial intelligence, biotechnology, nanotechnology. So these technology growth. So when the innovation and economic growth happens, the laws need to change. The laws need to adopt the new technology also. So this Indian Patent Act needs that technological advancements. Next, trademark and geographical indications in India. Trademarks. Basically, these trademarks was protected by the Trademarks Act 1999. Before that, this was also governed by some Patent Act in 1950s. After the post-independence, we are enacted those laws. So that was followed till 1999. But in 1999, we made a separate enactment to deal with these trademarks. So this Trademark Act 1999 protects distinctive marks used to identify goods and services. It aims to prevent consumer confusion and protect the goodwill of the business. If you see so many in these days, it is very commonly we are observing that the trademarks are used differently. If you see Adidas trademark is started with some small bar, big bar, and another big bar. But the Adidas, the latest, the infringers used the reverse order, or Nike tick mark, they can use reverse. So like that, they are using these trademarks. So to prevent this consumer confusion and to protect the goodwill of the business, this act was enacted. The registration of a trademark grants the owner exclusive rights to use it in the connection with the specified goods and services. The act also covers a wide range of marks, including brand names such as Adidas. We can sometimes Boss. They can we are visualizing that, or Nike in the name of Mike. So and brand names such as brand names, logos, slogans, and even colors also they are infringing. So this trademark includes the brand names, logos, slogans, and even colors. It also includes provisions for the protection of well-known trademarks, ensuring that they are not infringed, even if they are not registered in India. Geographical indications. What do you mean by geographical indication? Basically, geographical indication specifies particular place in connection with that product. So the Geographical Indication Act, the Geographical Indication of Goods Registration and Protection Act 1999 protects the origin and quality of products associated with a specific geographical location. This protection is granted to products whose quality, reputation, or other characters are attributable to their geographical origin. Examples from there: Kanjivaram saris, basmati rice, Darjeeling tea. So, like there are some geographical indications. What is the importance of trademarks and geographical indication protection? So, both trademark and geographical indications play a vital role in building brand identity, fostering consumer trust, and promoting fair competition. They protect consumers from counterfeit goods and allows business to leverage the reputation and value associated with their products. So the Indian legal framework for trademark and geographical indication protection has been instrumental in safeguarding the interests of Indian business, promoting innovation and ensuring the quality of products associated with specific geographical locations. See the geographical indications. For some examples are there. Darjeeling tea. What is the famous for? A black tea produced in the Darjeeling district of West Bengal. Kanjivaram saris, a silk saree in the Kanjivaram region of Tamil Nadu. Mysore silk, a silk produced in the Mysore region of Karnataka, renowned for its quality and history. If you see in the recent days, we are observing that in the news, there is some adulteration happening in the Tirupati Balaji Laddu, the prasadam, which was given in the Tirupati. So that is also geographical indicated mark. So it is famous for the place of Tirupati Balaji Laddu. It has also indication in geographical GI tag. Protection of traditional knowledge and cultural experiences. So there is this concept lately emerged, the protection of traditional knowledge. Because if you see, especially before we observing that registering the like some traditional knowledge, neem and this haldi, turmeric powder, we are using that for some antibiotic purpose. Before that, the Western countries, they registered on their name as a patents. But we are fighted in the International Arbitration Court and successfully we are written back that Indian products, those turmeric powder and the neem leaves medicine, which was used in the pesticides. So traditional, for the protection of this traditional knowledge and cultural expressions, we are using traditional knowledge digital library. So we are making some library. And at the same time, the protection of traditional knowledge bill also introduced in 2016. It was not to be lapsed, but it was under consideration. It was sent to the steering committee during that time. Still, there is in ongoing the discussions of that bill, traditional knowledge bill, and so a database that documents and protects the traditional knowledge, including medicinal plants, folklore, and the traditional crafts. The Protection of Traditional Knowledge Bill 2016 is a proposed law that aims to provide legal protection to traditional knowledge and cultural expressions in India. International cooperation. India actively participates in international initiatives to protect traditional knowledge, including the World Intellectual Property Organization's WIPO. The copyrights and related rights in India. The copyrights law in India and its related rights, digital environment rights, importance of copyright protection. The copyright, which was deal with the Copyright Act 1957, it protects original literary, dramatic, musical, and artistic works. If it grants authors and creators exclusive rights to reproduce, perform, adapt, and distribute their creations. These rights are subject to certain limitations and exceptions, such as fair use and educational purpose. Fair use in the sense, if you think that it is a musical concert, some 5-6 years back, there is a one singer and one music producer. There is some quarrel between them. The director name is Ilayaraja. He was issued some so-cause notice to then great singer S.P. Balasubramanian by singing the Ilayaraja composed songs in the some American concerts. During that time, he was not commercial. S.P. Balasubramanian was not used commercially, but he used in fair usage. So the court does not take any action against them. And educational purpose. If you, for a purpose of studying, you can print out the original author's book, but you cannot use in the commercial purpose. So for the downloading of any particular document which someone is author, it is not a infringement of copyright law. But if you use that book in the commercial purpose, then it becomes infringement of the copyright. Related rights. The Act also protects related rights such as rights of performers, such as before I said that S.P. Balasubramanian sing the songs of Ilayaraja, and producers of sound recordings and broadcasters. These rights ensure that these individuals and entities are recognized for their contributions and can benefit financially from their work. In the digital environment, the copyright framework has been adopted to address the challenges of the digital environment, including online piracy and unauthorized distribution of the copyright works. This act also includes the provisions for the digital rights management, online copyright infringement, and the protection of digital content. So before that, we are using CD and CD piracies, DVD piracies. But in these days, not we are using the CDs, but on the base, at the same time, we are using online pirated, online like movie rules, some iBomma type apps we are using and downloading that movies, whatever we want. So that was also comes under online piracy, digital piracy. What is the importance of copyright protection? Copyright protection is necessary because to fostering the creativity and incentivizing innovation, the copyright protection is essential. Because if you are not protect the copyrights, then it discourages the authors and artists to create new works. So because of that, you have to encourage the protection of the copyright. Next, industrial design and trade secrets in India. So industrial designs deals with the Designs Act 2000, protects the aesthetic features of industrial products. It grants exclusive right to the owner of a registered design to use, sell, or import products incorporated the designs. These rights are typically granted for a period of 10 years. And the trade secrets. Trade secrets are confidential information that provides a business with a competitive advantage. They are not formally registered, but they are protected under the law of confidentiality. For example, customers lists, formulas. If anyone some person makes some, we are using the tea powder which was blended with two or more tea powders, not raw tea powder we are consuming right now. Because if the raw powder, some powder will give color and some powder will give taste, some powder will give smell like that. So because of that, someone like if you 3 roses, they mix some quantities and release that product in the market. So if you cannot ask the what quantities they are mixing, so that is the trade secret. What is the importance of the protection? The protection of industrial designs and trade secret is crucial for the business as it allows them to maintain their competitive edge, leverage their unique features, and prevent unauthorized copying of their products and process. Enforcement challenges. What are the enforcement challenges, sir? So while the legal framework provides strong protection for industrial design and trade secrets, enforcement can be challenging, particularly in cases involving complex technology or confidential information. So enforcement of IPR in India. In India, what type of enforcement are there? So in the case of civil litigation, the owners of intellectual property rights can file a civil suit in the court to enforce their right against infringements. In the case of criminal proceedings, in certain cases, intellectual property rights infringements can be criminal offense leading to fines and imprisonments. So there is a thin line between the difference between civil and criminal proceedings. In the case of civil proceedings, the punishments should be awarded in the pay damages only. But in the case of criminal, so along with the damages, the offender can also imprisonment. Next, the administrative action. The Indian Patent Office and the Trademark Registry and the Copyright Office, they have authority to take administrative actions against infringers, such as issuing cease and desist orders or initiating revocation proceedings. And in the border measures, custom authorities can prevent the import and export of goods that infringe intellectual property rights. And in the case of alternative dispute resolutions, the owners can go with the arbitration and mediation to resolve the disputes because of effective and timely manner. So this is the enforcement mechanism of IPR in India. What are the challenges and opportunities in the Indian intellectual property rights landscape? So we have to create IPR awareness due to this vast advancement of scientific technology. So we have to create IPR awareness in the society. Next, we have to maintain the balance in between innovation and access. Especially the Indian IPR framework faces the challenges of balancing the interests of the investors with the need to ensure access to affordable healthcare, education, and essential technologies. Filling the right balance is crucial for achieving both innovation and societal well-being. For example, if you see during the PV Narasimha Rao government, during the time of that decade, India is facing polio very highly. India is affected with polio very high, severe rate. During that time, PV Narasimha Rao made a statement that we will eradicate the polio within a decade. Consequently, in that time, the World Health Organization also thinks that what the nonsense the India was speaking on the international diaspora. They speak anything, whatever they want, without they are doing work like that. They are making some blames against the Indian diplomats during that time. But after the 10 years, what we are observing right now is India is the country which successfully eradicate polio. At the same time, Indians, the government take it prestigiously and they give it free to the people of India, every children. It is free. We are making as a campaign like for 2 to 3 months. We are giving the polio vaccines. So by doing that, with taking no money from that vulnerable section. So we are offering that polio vaccine. So finally, we are eradicating the polio. At the same time, so many Western countries now they are importing our polio vaccine with very less uh, money. So this must be a concern for the challenge improvement of the intellectual property rights and enhancing enforcement, strengthening of intellectual property right enforcement mechanism is essential to deter infringement, protect the rights of owners, and ensure that the legal framework and effectively safeguard innovation and creativity. This includes improving coordination between different agencies, streamlining procedures, and increasing resources. Emerging technologies, as we are know that due to the emerging the scientific technology and artificial intelligence, biotechnology, nanotechnology, this poses new challenges and opportunities for the IPR protection. What the India's role in global international framework? So India's role is international engagements. First one, that is India is the active member in the World Intellectual Property Organization, World Trade Organization, Paris Convention, Patent Cooperation Treaty, Patent Law Treaty, TRIPS Agreement, like that. We are everywhere. We are in every organization. We are part of that organization. And second, making the bilateral agreements. India has entered into so many bilateral agreements with several countries to facilitate the exchange of information and the global leadership. As I am told already that previously discussed that we are now exporting the polio vaccine along with so many vaccines we are exporting like that we see in the during COVID, after COVID, we are exporting the Covaxin, Covishield to the outer countries. So this is called as some global leadership. So this is advocating the balanced approach that promotes innovation and access to essential technologies. At the same time, protection of traditional knowledge. And we are also addressing the global challenges in the international dais by citing that protection of traditional knowledge. So the another emerging technologies, also digital technologies and international cooperation. Now, what is the acquisition and maintenance of these intellectual property rights? We already see these types of intellectual property rights, copyrights, creative works, patents and inventions, trademarks, acquisition and intellectual property rights. So how we can acquire the international intellectual property right? First, application and registration procedure. Most intellectual property rights, such as patents, trademarks, and copyrights, requires a formal application and registration. So without the application, you can't ask the protection with regarding to the patent, trademarks, copyrights. So this involves filing a formal applications with the relevant government agency. For example, if you want to patent, You go to the patent protection officer, a trademark office, copyright office. So this involves filing of the application to the concerned agency or organization, satisfy the specific requirements what they provided, what they requires. Later, examination and grant. Once an application is filed, it undergoes examination by the relevant authority. If the application meets the eligibility criteria, then only the intellectual property right is granted, providing the owner with exclusive right over their claim. Exclusive right means both he can utilize for commercial purpose also. He can give someone else. Yes, I can provide the through the link, no problem later. After the coursework, I will provide the all slides. So the maintenance and renewal. The intellectual property right, basically, so many rights are not given entire life. For example, if you see the patents, it will give only 20 years. If you see that the trademark, it gave only 10 years validity. So in the copyright, you have the end of the author. So after that, that comes under the public domain. So in that case, for the maintenance and renewal, we requires. So particular fee is provided for that maintenance and renewal. If anyone fails to comply with these requirements, they can result in the loss of protection and it comes under the public domain. The maintaining and enforcement of intellectual property rights. So monitoring for infringement. So it is essential to monitor the market for potential infringements of your intellectual property rights. This involves researching the market and identifying any unauthorized use or imitation of your protected creations. And legal action. In case of infringement, legal action may be necessary to protect your intellectual property rights. This can involve filing a lawsuit, seeking an injunction, or pursuing other legal remedies to stop the infringing activity and recover damages. Alternative dispute resolution. In the case of alternative dispute resolution methods such as mediation or arbitration, they can be used to resolve the IP disputes without resorting to the litigation. As we all know, the litigation is more time consuming, both cost effective, but it is a very time consuming. Because of that, sometimes the owners of the intellectual properties thinks that it is I want to leave that if they give the in favor of the judgment, okay, otherwise I am very tired to run behind the courts. So they can go with the ADR option also, alternative dispute resolution methods. It is a cost effective method at the same time consuming methods also. Next, licensing and agreementing. So the intellectual property rights licensing agreements can be used to grant other permission to use or exploit your protected creation in specific ways. These agreements specify the terms of use, payment, and other relevant details. So intellectual property licensing and agreements. So what types of licenses are there? There are various types of licenses, IP license, including exclusive license, non-exclusive license, royalty-based license. Exclusive license means he has the complete owner. He can do whatever he wants with that patent or copyright or intellectual property. Non-exclusive license means sometimes they will issue for particular purpose only. For example, they are used some properties they can have possession right only, but they don't have ownership right. In that same case, the intellectual property sometimes they have right to use, but he has no right to sell. In the case of benefits of licensing, licensing can be beneficial way to monetize intellectual property. Intellectual property, monetize intellectual property rights. So it can also provide access to new markets and technologies, fostering innovation and collaborations. Considerations for licensing. So before entering into a licensing agreement, it is crucial to consider factors such as the scope of the license, royalty rates, duration, and the termination clauses. Ensuring a comprehensive and well-drafted agreement protects the interests of both the parties. So, what are the emerging issues in the case of intellectual property rights? So, the emerging issues, intellectual property rights are cornerstone of modern economics, protecting creations of the mind and fostering innovations and technological. As technology evolves rapidly, so do the challenges and opportunities surrounding the intellectual property. This presentation involves averaging the issues in IPs. What are the challenges? Challenges in the digital area with regarding to copyright. Copyright infringement. The digital age has made it easier than ever to copy and distribute copyright material, leading to a surge in infringement cases. Online platforms, file sharing services, and rise. The piracy presentation significant challenges and copyright holders. Someone is put a message that in the case of geographical indication, circling back to geographical indication, who can register a geographical indication? So the person on behalf of the state can register geographical indication. Who is it protected from? State itself is protected. Who is allowed to use a geographical indication? Again, state. So geographical indication is with regarding to the state protection only, not any particular person's protection. For example, if you see the dispute is ongoing now, the Tirupati Balaji Laddu. So for that, the protection is the what do you call the reputation of the state links with the geographical indication, the particular place. So if a particular place locked with that usage of that, then the state will comes into the picture. Whoever infringes, they will file a case against the infringer. So this geographical indication is not a personal use; it is a state's interest. Next, in the second challenge in the copyright in the digital age, fair use and copyright law. So determining the fair use boundaries in the digital age is a complex issue, balancing the rights of copyright holders with the public interest in accessing and sharing information remains a critical concern for policymakers and courts. And the third challenge is copyright protection for new technologies. Due to the emerging technologies such as artificial intelligence and blockchain, the rise new questions about copyright protection. So the artificial intelligence generate content and blockchain-based ownership models present unique challenges that require careful consideration. The fourth one is international copyright law. So with the globalization and the interconnectedness of digital markets, harmonizing copyright laws across different jurisdictions is crucial, ensuring the consistent protection and enforcement of copyright law is essential for fostering international trade and collaboration. The trademark infringement in the global market. So cyber squatting, the increase in the use of the domain names has led to a rise in cyber squatting, which where individuals or entities register domain names that are similar or identical to established trademarks. This can harm brand reputation and confuse the consumers. This is called cyber squatting. Next, counterfeiting. So global trade has facilitated the proliferation of counterfeit goods, which infringe our trademarks and can harm consumers' health and safety. Combating counterfeiting requires international cooperations and effective enforcement mechanisms. The third one is parallel imports. The practice of importing goods from other countries without the authorization of the trademark holder, it is also known as parallel imports, can raise questions about trademark infringement and consumer protection. So, for instance, if a company incorporated in Delhi wants to sell Darjeeling tea, how do they get a license to sell if they need one? Okay, if you want to sell a Darjeeling tea exclusively in the if in a tea shop, there is no product, there is no not required that um, they can easily purchase the tea powder and use, no problem. But if a company incorporated Delhi wants to sell Darjeeling tea under the name of Darjeeling or any other else, if they sell the Darjeeling tea only, which was labeled as a Darjeeling tea, nothing was required to license because it was naming as a Darjeeling tea. But if that Darjeeling tea was further same product, same Darjeeling tea, you are importing as a Delhi some, you can give a name AA company, and on the name of AA company, if you sold that Darjeeling tea, then it is a infringement. If you want to sell Darjeeling tea, which a company incorporated in Delhi, then you can, no problem. But on the name of some other else, if you want to sell the Darjeeling tea product by changing the Darjeeling name, so then you want, that is comes under the infringement. Okay, Akash. Next, patent trolls and the impact on innovation. So patent number one is patent assertion entities. There are some entities are there, these are known as patent assertion entities, often referred to as patent trolls. This acquires patents with the primary goal of asserting them against business, often seeking licensing fees or litigation settlements. What is the impact of innovation? So patent trolls can stifle innovation by imposing high litigation costs on business, particularly startups and small enterprises. This can discourage investment in research and development, slowing down the technological progress. There is patent reform efforts are also there. The efforts to reform patent law and curb patent troll activities are underway in various countries. These reforms aim to strike a balance between protecting intellectual property and promoting innovation. So, trade secrets and the rise of cybersecurity threats. Yeah, these are protecting trade secrets. Trade secrets are confidential information that gives a business a competitive advance, as we have already discussed the blending of tea product. So, the protecting trade secrets is crucial for maintaining a company's competitive edge and safeguarding its intellectual property. Next, cyber security threats. The rise of sophisticated cyber attacks poses significant challenges to trade secret protection. For example, data breach, malwares, malware attacks, and ransomware attacks can compromise sensitive information and damage a company's reputation. Next, cybersecurity measures. Companies must implement robust cybersecurity measures to safeguard their trade secrets. These measures include strong passwords, secure network, firewalls, intrusion detection systems, and employees training. These are all required for the cybersecurity. And data privacy laws. Data privacy laws such as General Data Protection Regulation, in the case of European Union, and the California Consumer Privacy Act, CCPA. At the same, India also passed this Data Privacy Act latestly. These impose obligations on companies to protect personal data, which can include trade secrets. So geographical indications, protecting logical economics, protecting the local products. Geographical indications are signs used on the protect products that have a specific geographical origin and possess qualities or a reputation due to that origin. So these geographical indications protect the unique characters of products and foster regional economies. For example, day before yesterday, I saw that some wine is preparing in the French. So it was named on that the place. So that is geographical indication of that product. So what are the international agreements regarding to geographical indications? The international agreements such as agreements on TRIPS, trade-related aspects of intellectual property organizations, these provide a framework for protecting geographical indications. So these agreements ensure for fair trade and misuse of geographical indications. They prevent the misuse. Promoting local economies. To protect the geographical indications by protecting and the reputation of the authenticity of the products, it will promote the local economies. They encourage investment in quality production and contribute to the preservation of traditional knowledge and craftsmanship. What are the challenges with regard to geographical indications? The protecting geographic indications involves addressing challenges related to enforcement, consumer awareness, and the impact of globalization on local economies. Utilizing technology and fostering international cooperation are key to promote the use and effectiveness of geographic indication. This international intellectual property right and traditional knowledge. Traditional knowledge encompasses knowledge, involves and practices developed by indigenous and local communities over generations. At present also, if you see the movie of Seventh Sense, so it was a one of such traditional knowledge. In that movie also, which is widely shown, the transform of the traditional knowledge from here to China. So this is the protecting of traditional knowledge is very essential for preserving cultural heritage and ensuring equitable benefits for communities. So for the protection of this traditional knowledge, they killed their Bodhidharma in this movie of Seventh Sense. So what are the legal framework with regarding to this traditional knowledge? So the legal frameworks are being developed to protect traditional knowledge, such as sui generis systems that provide specific legal protection for traditional knowledge. These frameworks aim to ensure equitable access to and benefit sharing from the traditional knowledge. Challenges to protection. So, protecting traditional knowledge faces challenges relating to documentation, ownership, and commercialization. Even though right now, if you go in the forest stretch of this India, if you go in the forest areas of Jharkhand, Chhattisgarh, Andhra Pradesh, Tamil Nadu, they're using their own medications. They're not using this Western or English medicines. They're using their own medication to treat the diseases. So This requires documentation, otherwise it will a challenge for the protection. And at the same time, you cannot decide who is owner of that particular traditional knowledge. So for the commercialization, everyone needs to exploit that traditional knowledge. So balancing the rights of communities with the interests of researchers, business, and the public remains a critical issue. So what is the international cooperation in the field of traditional knowledge? In the case of traditional knowledge, the WIPO, World Intellectual Property Organization especially, it emphasizes the protection of traditional knowledge. No, under what is traditional knowledge protected? Trademark or copyright? It is patent. It is patent, not trademark or copyright. Because most of the traditional knowledge is in medicine only, na? So medicines are patentable. Okay. So these are essential for fostering equitable and balanced sharing. So the balancing intellectual property rights with public access and fair use. So intellectual property rights, public access and fair use. Exclusive rights grants to the creators and inventors. So the exclusive rights means it's allowing the public to access and use copyrighted work for certain purpose. We are saying that in the exclusive right, they can use for fair use and educational purpose. At the same time, encouraging innovation and investment. To encourage innovations, you should provide in the education field and research field and in cultural expression. And third, the protecting commercial interests. So to protect commercial interests, they're ensuring freedom of speech and access to information. So what comes under public access and fair use? For the commercial interest, in the case of commercial interest, you just freedom of speech and access to information is available. But in the case of some like trade secrets, that cannot be possible. And last one is potential for abuse or overaction, potential for copyright infringement or misuse. So this was comes under the balancing of intellectual property rights with public access. So what are the emerging trends in intellectual property valuation and monetization? So what the trends? First one is data-driven valuation. The use of data analyticals and machine learning is transforming intellectual property valuation. Big data and artificial intelligence algorithms can provide more accurate and comprehensive assessments of the value of intellectual property. And in the monetization strategies, new monetization strategies are emerging, such as licensing agreements, joint ventures, and a technology transfer partnership. So these are innovative technology, innovative things. Previously, there is no joint ventures. If anyone has IP, he has the exclusive right. But due to this new joint venture option, he can transfer his some of his rights to his friend or his partner. And a technology transfer partnership also like that only. So companies are exploring innovative ways to leverage their intellectual property to generate revenue. And the third one, intellectual property portfolio management. The effective intellectual property portfolio management is becoming increasingly important because the companies need to carefully assess their intellectual property assets, identify potential licensing opportunities, and develop the strategies for maximizing the values of their intellectual property. And the final one, the IP finance. In intellectual property, finance is gaining traction as a source of funding. Investors are increasingly recognizing the value of intellectual property and providing capital to business based on the strength of their intellectual property portfolios. So, what are the future of intellectual property rights? in consideration with policy consideration, as we are talking about the increasing of artificial intelligence. The artificial intelligence poses a significant challenge and opportunities for intellectual property rights. Determining the ownership, copyright, and liability for artificial intelligence generated works is a complex issue that requires policy attention. Next, data protection and privacy. As data becomes increasingly valuable, ensuring its protection and respecting privacy is a paramount. Policymakers need to strike a balance between fostering innovation and safeguarding individuals' data rights. At the same time, international cooperations. So global cooperation is essential. So India is part of uh, all form of conventions which are related with the intellectual property rights. India is also a member. Public engagement. So the promoting the public awareness and understanding of intellectual property rights, it is essential to foster the cultural of innovation and ensuring these rights benefits to the society. If you are making an innovation, if the innovation is need for the normal people, but you placed the cost of that innovative product is very high, then what is the use? So because of that, the public engagement is necessary. The society, you should use those to the benefit of the society. So that is with regarding to emerging issues of intellectual property rights. Next, the role of patents in promoting invention, innovation, and technology development. So understanding the patents, you all know the definition of the patent. A patent is a legal right granted by a government to an inventor for a specific invention. It allows the inventor exclusive right to use, sell, or make their invention for a limited period. As I said, regarding to patent, the limited period purpose of the patent is patent also promotes the dissemination of knowledge.
హలో మిస్టర్ రమణమూర్తి గారు, వాయిస్ లేదు. No voice.
Okay. My voice is audible because I lost the signal.
Okay, no problem. No, students are asking.
Okay. So due to the environment here, no problem. That's right. Am I audible now? Akash, am I audible now? Yeah, okay. So with regarding to exclusive right, I already told that patent grants inventors exclusive rights to exclude others from making, using, or selling their inventions. These rights can be enforced through legal action if someone infringes on the patents. So as I already told that what is exclusive right? The making, using or selling, he has exclusive right. That means he has ownership. Next second, limited time frame. Patent rights are not perpetual. Perpetual means forever they are coming, like the property. Our forefathers' property comes to our father's property comes to our property goes to our children. Like that, it was not comes. Patent rights are not perpetual. They are granted for a limited period, typically 20 years from the date of application. This encourages competition and ensures that invention eventually enter the public domain. At the same time, disclosure requirement with regarding to patent, the disclosure of the patent is required for registration of the patent. If you are not disclosing the invention, how can you someone recognizes the patent was under the name of someone? So because of that, the patents must be registered, disclosed. The patent system structure and process. Same, and every intellectual property has same structure. So in the, as like the patent system operates as a complex and multi-phased legal framework, it involves various actors, including inventors, patent examiners, attorneys, and the courts. The process of obtaining a patent typically begins with the inventors filing a patent application with the relevant patent offices. Okay, this application must be included a detailed description of the inventions, drawings, and claims that define the scope of the patent. So the patent application, you have to first make the patent application with regarding to the patent office. During a patent application pendency, is the patent disclosure in public domain at that time? So basically here two questions arise, two concepts arise. First, there is a, in India, if you want to apply the patent application, so there is a two type of applications, primary application and secondary application. If now you want to, like the cinemas, the people are registering their names. Okay, so first before he he went to shoot, the director went to shoot the picture, he registered the name of the picture. So for that, some time period is there. For the in that during that time period, others should not make any picture based on the title. As like same as in patent system also. In the case of patents, first you have to make an application. So when you make applications, there is no pendency of too much time until unless your patent application is replicating someone else. Okay, if it is new, then it will be immediately the grants. So the initial registration will be happens. So for that initial registration, you should given a period of 1 year. So during that 1 year, you should complete the patent procedure, and later that you can he has to disclose. The time was given by the patent office. Okay, the patent office gives some time. So during that time, you have to complete that patent and you have to publish at the end of the date given by the patent office. So if you are not submitting the final report during that time, so your patent application, which was earlier registered, was deregistered. Okay, cancelled. So that is the procedure. So after the patent application, the examination will happen with the patent office. In that patent office, the examination is going with whether you are making some application, whether that application is patentable or not. For example, some application, some items on which you want patentable, those items are prohibited by the government not to issue patents on those products. So during that case, if anyone applies for the patents, generally patent office is not to give the patent registration. Next, the grant or rejection. If the patent application is approved, the patent office grants the patent. Incentivizing invention, how patents promote innovation. The primary function of patent is to incentivize inventors by providing a legal mechanism to protect their creations and reap the financial and reputational rewards of their innovation. This incentive structure encourages individuals and business to invest time, resource, and expertise in research and development. So, by granting inventors exclusive rights, can a patent application be opposed during pendency? So basically, yeah, I already told you that the procedure of pendency is very limited time. They can oppose it. You are asking the question with regarding to whether the patent office can oppose it during the pendency of time, can oppose it to grant the patent. Yes, if that is, the answer is if on the product. You mean third parties? Third parties are prohibited. No one will issue that patent to the other. If if you want to make some, if you want to innovate some product, okay. So first you have some idea, then you go to today you go to the patent office and registered something. So they give 1 year period of time. So during this 1 year period of time, if anyone comes, then they will not allow to others. Okay, because it was registered on your name only. So after the exactly 12 months, if you are not go with the final report of that innovation, then yours will be cancelled. Your first application will be cancelled. Okay, if you go with the innovation, then it is suitable for granting a patentability, then they issue patentability by the prior date. Okay, that was clarified. Yes or no? Akash. Okay. So this incentivizing innovations, which basically it promotes innovation only. Patents promotes innovation. The financial rewards, you can got the financial rewards by innovate some patents. At the same time, reputational basis also, market exclusivity, strategic advantage. This all the promotes innovation. So the protecting intellectual property, the role of patents. Patents plays a crucial role in protecting intellectual property, providing a legal framework for inventors to secure exclusive right to their creations and prevent unauthorized use or exploitation by others. So preventing infringement. So patents provide a legal basis according to the Patent Act 1970 and the 2005 amendment. It provides a legal framework for inventors to take action against any others who infringe on their intellectual property rights by making, using, or selling their inventions without permission. Enhancing market value. Protected inventions can be licensed or sold to other companies, generating revenue for the inventor and contributing to the value of the inventions in the marketplace. So, the inventor, he can give his licensed patent to the companies in other company by generate some revenue. At the same time, facilitating investment. Patents also demonstrate the legal protection of an invention, making it more attractive to investors who are seeking to fund research and development activities. Fostering technology development, patents, and commercialization. Yes, because of the technology development, how the patents are commercialized. Patents can be used in research and development. Patents incentivize inventors to invest time and resource in research and development. Second one is invention. The promise of patent protection encourage the development of new inventions and technologies that address the social needs and changes. Commercialization, as we already discussed, commercialization. So the inventor gives some companies, and the companies give some amount to invest inventor. Market adoption, the commercialization of patent technologies leads to the wider market adoption, driving further innovation and technological progress. So the international patent landscape, global trends and challenges. So what in the international market, what is the challenges they have? So increased cross-border patent filings. So if a person who is in India applying the patent, someone will else in applying the same product as a patent in USA also. So this is the issue, increases the cross-border patent filings. Or someone who is applied in India and went before, as I previously told that the primary reporting was done before the 12 months. There is a period between first registration and second registration. The first registration if they're done in India, the second registration if they're done in Britain, then there is a increase. This type of cross-border patent filings are happening. So to harmonizing of the different patent systems. So what Indian Patent Acts told and what US Patent Act or British Patent Act told. So because of that, the World Trade Organization established, they make some guidelines regarding the generalized universal principles, so which should follow to overcome these harmonizing the different patent systems. So this comes under the main challenge. Ethical considerations. Next is technology transfer. How the technology is transferred. So we are already know the types of intellectual property rights, patents, to operate trademarks. Yes, the role of technology transfer in intellectual property rights. So the technology transfer. What is this technology transfer? It is a act of that transforming scientific discoveries and the technological advancements into tangible products and services that benefit society. So the idea are intangible, but using that intangible idea, making some tangible products and services that benefit society. This is the technology transfer. So it facilitates the movement of innovations from the realm of research and development to the marketplace. So it involves several key steps, including identification, evolution, negotiation, implementation. So identifying promising technologies with commercial potential is the initial step in technology transfer. This requires a careful assessment of the technology's novelty, market demand, and feasibility of development. The second is evolution, a comprehensive evaluation of the technology's strengths, weaknesses, and the potential risk is crucial before proceeding with transfer. This involves assessing the technical viability, market competitiveness, and regulatory compliance. Negotiations, the negotiation, implementation. So these are the technology transfer. So licensing and commercialization of intellectual property rights. So licensing methods. So licensing methods, we already know that exclusive license is given, non-exclusive license is given, royalty-based license, lump sum license also given. We know the commercial strategies. commercial strategies, successful commercialization, market research, product development, marketing and sales, distribution and support. What are the challenges in the technology of transfer? Challenges is especially lack of awareness, funding constraints, cultural differences, legal and regulatory issues. So lack of awareness, the awareness among the researchers, business, policymakers, this leads to the technology transfer opportunities ineffectiveness. Second one is funding constraints. Insufficient funding for research and development as well as technology transfer activities can create a significant barrier to successful commercialization. Third one, cultural differences. Difference in culture, language, and business practices between researchers and business can create communication gaps and complicate technology transfer process. And final one is legal and regulatory issues. Complex issues and regulatory frameworks surrounding intellectual property rights and technology transfer can present significant hurdles. What are the strategies for effective technology transfer? So in the previous slide, we have to see the challenges and barriers. Now, what are the strategies for the effective technology transfer? So the strategies are strong communication, mentorship and training, market research, intellectual property protection. So this was related with this the previous slide, challenges and barriers. The importance of collaboration and partnerships. Yes, this is all very important. The collaboration of partnerships play a crucial role in the fostering of technology transfer. So in the case of universities, research institutions, companies, government agencies, industry associations, venture capitalist firms, non-profit organizations, these are all play a significant role in the collaboration and the partnerships to promote the technology transfer. So what are the regulatory framework in the technology transfer? So the regulatory framework is intellectual property protection. One is intellectual property protection. Second one is licensing agreements. Third is financial incentives. Fourth is technology transfer offices. So these are all the frameworks we should need to provide a successful technology transfer. So intellectual property protection, you need that intellectual property protection because some products which are, even though non-existence, you can give that intellectual property, but even though some some innovations are done, but if you are not registered, then you cannot got any protection of intellectual property rights. So intellectual property protection is important. So licensing agreements are necessary, and financial incentives. Government should provide financial incentives to provide technology transfer. So for that purpose, you have to maintain some technology transfer offices. And the introduction of traditional knowledge, protection of traditional knowledge. So we all know what is traditional knowledge. This traditional knowledge is nothing but the knowledge known to the indigenous people. So the traditional knowledge, also known as indigenous knowledge, encompasses the vast body of knowledge, practices, and beliefs accumulated by indigenous peoples over generations. This knowledge system is deeply rooted in their cultures, languages, and the relationship with their natural environments. Traditional knowledge cover a wide range of areas, including agriculture, medicine, astronomy, ecological management, and sustainable resource use. It represents a rich and invaluable repository of wisdom that has guided generations and continue to hold immense significance for the well-being of indigenous communities and the planet as a whole. So what are the importance of traditional knowledge? The importance of traditional knowledge in several key areas, like in sustainable practices. So, traditional knowledge often emphasizes sustainable resource management and conservation because indigenous communities have developed an intricate system for managing land, water, and other natural resources, ensuring their long term availability. The second one is biodiversity conservation. So, because of this, indigenous communities have deep connection with their ecosystems and they possess good biodiversity. And third is cultural heritage. So, this traditional knowledge is an integral part of indigenous cultures, preserving their history, values, and traditions. So, it connects with generations and provides a sense of identity and belonging. Next, next one is health and well-being. In the case of traditional knowledge system, often contains valuable insights into medicinal plants, natural remedies, and health practices. These practices have been used for generations and can provide effective solutions for various ailments. So, what are the challenges in protecting the traditional knowledge? Despite its significance, traditional knowledge faces numerous challenges in modern world. Number one is commercialization and exploitation. As I already discussed this, the traditional knowledge is increasingly being exploited for commercial gains without proper recognition, uh, compensation for indigenous communities. So this also includes unauthorized use of traditional medicines, genetic resources, and cultural expressions. Second one is erosion of traditional practices. Due to this modernization, globalization, and assimilation pressures are led to the erosion of traditional knowledge systems. The younger generations may not be adequately exposed to these practices, which results in a loss of valuable knowledge. And last one is the lack of legal protection. The traditional knowledge system often lack formal legal protection, leaving them vulnerable to appropriate and misuse. So we are in India also we are passing a bill, but still the bill had to be we are introduced a bill, but still the bill had to be become an act. So this is one problem with regarding to the protection of traditional knowledge. So what are the international framework for the protection? So international framework, the Convention on Biological Diversity, CBD, it focuses on the conservation and sustainable use of biodiversity, including the protection of traditional knowledge associated with biological resources. At the same time, the UNDRIP, United Nations Declaration on the Rights of Indigenous People, it also recognizes the right of indigenous people to maintain and revitalize their cultural traditions, including their knowledge systems. And finally, WIPO, World Intellectual Property Organization, it provides a platform for discussion and negotiations on the protection of traditional knowledge within the framework of intellectual property rights. What are the national policies and legislations with regarding to traditional knowledge? Especially, first one is the recognition of the traditional knowledge, right? National legislation, there is yet to be a complete national legislation on the traditional knowledge protection, but it recognizes the rights of indigenous communities to their knowledge systems, including their ownership, control, and access rights. Second one is informed consent and benefit sharings. So most of the policies they can require the informed consent from indigenous communities before their knowledge commercially exploiting, but they're exploiting the traditional knowledge only. Cultural heritage protection. National laws can protect the traditional knowledge as part of cultural heritage, addressing issues like the unauthorized use of cultural expressions and traditional ceremonies. And capacity building and education. National policies can support capacity building in education programs for indigenous communities to help them understand their rights and manage their knowledge system activities. So, what are the role of indigenous communities in the protection of traditional knowledge? So, because the traditional knowledge belongs to this indigenous community, so they play a critical role in the protection of and the revitalization of the traditional knowledge. So, their active participation is crucial for ensuring the knowledge is preserved, respected, and utilized in a way that benefits them. So, what are the key roles of the indigenous communities? Number one is knowledge keepers. Number two is decision makers. Number three, advocates and educators. So, in the knowledge keepers, indigenous communities are the custodian of their knowledge systems, responsible for preserving, transmitting, and updating their traditional practices. So, these indigenous communities are the custodians of the knowledge system. Second, decision makers, the policy makers. The indigenous communities should be involved while taking the decision with regarding to the protection of their knowledge. So this includes negotiation benefits, access conditions, and ensuring that the interests are represented. Advocates and educators. Indigenous communities can advocate for the recognition and the protection of their knowledge, rights, and educate others about the importance of traditional knowledge system. So, what are the challenges with regarding to the traditional knowledge? The traditional knowledge system often lacks the formal documentation and structured period. As we are all discussed, that there is no documentation, there is no ownership. This so the challenges in accepting ownership and preventing unauthorized use. So, what are the possible solutions? Several approaches are being explored to address these challenges, including the development of some sui generis systems for protecting traditional knowledge and adopting existing intellectual property frameworks to accommodate the unique characteristics of indigenous knowledge. So, what are the preserving traditional knowledge? How you can preserve the traditional knowledge? So, documentation and digitization, language revitalization, community-based education, cultural exchange and collaboration. You can take these four steps to preserve the traditional knowledge. The first one is documentation and digitization. Second one is the language revitalization. Third is community-based education. How to provide community-based education. The role of transmitting the traditional knowledge to younger generations. And fourth is cultural exchange and collaboration. You have to collaborate with someone else to strengthen the traditional practices. So, what are the basic issues with regarding to this traditional benefits here? The key principles for responsible commercializing that includes free, prior, and informed consent. Indigenous communities must be given the opportunity to provide free, prior, and informed consent before their knowledge is used for commercial purpose. Second is equitable benefit sharing. Indigenous communities should receive fair and equitable benefits from the commercialization of their knowledge. These benefits include monetary compensation, access to technology, access to training, and other forms of support. The third one is cultural sensitivity and respect. The commercialization of traditional knowledge should be done in a way that is culturally sensitive and respect the values and benefits of indigenous communities. And the community control. Indigenous communities should retain control over their knowledge and have the right to determine how it is used and saved. So as of now, the traditional knowledge represents a rich and invaluable repository of wisdom that has sustained generations and continue to hold immense significance for the well-being of indigenous communities and the planet. So to protecting and revitalizing the traditional knowledge requires collaborative efforts involving indigenous communities, governments, researchers, and other stakeholders. This includes recognition and respecting the rights of the indigenous people to their knowledge system. So as of now, today I was discussed the overview of intellectual property, the first two chapters, the concepts of IPR. So that is what is the introduction of intellectual property rights. So what are the Indian acts which are involved in the intellectual property rights? And the third one is acquisition and maintenance of intellectual property rights. So for the acquisition, you have to go, there is just three stages: application procedure, issuing procedure, finally registering, and maintenance. We have to pay the fee for renewal. The emerging issues in intellectual property rights, in the emerging issues are this scientific technology advancement. This is the main key role in the intellectual property and for the emerging issues. Next, we are discussing the patent and technology development, especially what is known as patents and what comes under the innovation, invention, and technology development of patent. They're also called as technology transfer. How the technology transfer will go, what are the hurdles involved in the technology transfer, how you can redress those problems. Next, finally, we are also talk with regarding to this protection of traditional knowledge. How what is the traditional knowledge? How the traditional knowledge is going on, and how the people are exploiting the commercialization of the traditional knowledge is ongoing, and what are the requirements to protect the traditional knowledge. So, for this, I am concluding today's lecture. Tomorrow, I can deal with enforcement of intellectual properties and litigation and settlement of dispute in intellectual property rights. Okay. If you want any, if you have any doubt, please, if you ask to by unmute, or you can send a message in call messages. Okay, then I will conclude right now. So tomorrow, what book of IGNO to read up? No, they're providing some basic material now, MIR021. That material is enough. You can read that material, no problem. So that material is sufficient. That material is sufficient for study, no problem. Okay, thank you. So the group regarding students and faculty, I don't know exactly what is going on. So yesterday, sir also said that if you have any doubts, then directly inform to sir only. They will communicate us. Okay. Otherwise, if you have any doubt, then I am sending my number. You can ask me through this number, WhatsApp only. Okay. Okay, thank you.